The cornerstone of America's constitutional republic is the separation of powers. America's founders, seeking to break away from the autocratic rule of the British Crown, understood human nature and the associated dangers of concentrating power in one person or group of people. Thus, they created a federal government of checks and balances with three branches: executive or presidential, legislative, that's the Congress, and judicial, that means the courts. Each branch is both independent, with clearly defined responsibilities, but also interdependent. While the Congress is charged with passing new laws and spending public funds, it is unlikely to succeed without the assent of the president, who's charged with either vetoing or signing and enforcing the law, and the courts, which are responsible for interpreting and determining if the laws meet constitutional standards. Three current issues bring to light the brilliance and the significance of this separation and interdependence of powers. The issue of presidential authority when it comes to enforcing or not enforcing laws, whether those laws are popular or not, is at the heart of the controversy over the president's decision to exempt certain illegal immigrants from prosecution. Citing prosecutorial discretion, the president ordered the Department of Homeland Security to exempt certain people who were subject to prosecution. This avoided the need to wait for Congress to pass legislation, commonly called the DREAM Act, that would actually change the law, which only Congress can do. On the other hand, the president can issue executive orders, which change policy, but not law, and can be enacted or reversed at any time with a stroke of a president's pen. Though this change in immigration policy was not actually done through an executive order, the question that's being debated is whether the president pulled an end run around the separation of powers and exceeded the bounds of his constitutional authority in this case. Then there's the case of the so-called Fast and Furious gun-running scandal. The Congress launched an investigation and demanded over 100,000 documents from the Attorney General, who is part of the executive branch. The Congress argues that it has the right to ask for these documents because of their responsibility to exercise oversight. The president has cited executive privilege and ordered the Attorney General not to comply, arguing that the Congress is exceeding its authority and violating the separation of powers. It is possible that the third branch, the judiciary, may ultimately step in to serve as arbitrator and settle the issue. And when it comes to the separation of powers, there is no more high-profile example than the health care law passed 2 years ago. The president proposed the legislation, Congress passed it, and the Supreme Court will soon decide whether parts of the law or all of it violate the Constitution. These, like most constitutional issues, usually do not have clear black and white answers, but that is the beauty of the separation and interdependence of power and authority, the tension between the three branches of government that leads to vigorous debate. One way or another, we are now witnessing the heartening reality that such debate ultimately leads to a more transparent and renewed balance between the three branches of the federal government, and thus greater adherence to the U.S. Constitution.